Hey, we're going to break down a crazy rule, a nutty rule. It's an insane rule that lawyers must abide by. So I'm going to read it to you word for word. It's based on the Model Rules of Professional Conduct, which was published by the American Bar Association. But this is Nevada's version of it that I'm going to use as an example. And it states, a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. This paragraph does not apply when the client is an organization. So what we're going to do is we're going to take a deep penetrating dive into the analysis of this rule. And I'm going to go ahead and tell you up front that there's a lot of slippery slopes involved with this rule. So let's break down the first sentence. It's only 2 sentences long, so stick around. The first sentence says, a lawyer shall not have sexual relationships with a client. That's the first part of the sentence. So you're not supposed to have, sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. So how the lawyer-client relationship commences oftentimes is that the person comes to the lawyer with legal advice and they sign a retainer agreement. Some attorneys would argue that as long as you have sex with your client before they sign the retainer agreement, that's okay. If it's okay then you can continue to have those kind of relations throughout the lawyer-client relationship. So if you're an attorney and you're considering this, make sure that you bang out the deed before you bang out the paperwork. And now we're going to go to the second sentence. The second sentence says, this paragraph does not apply when the client is an organization. And what is an organization? Well, let's start. It could be a nonprofit. It can be an LLC. It can be a partnership. It could be a corporation. And so the rule doesn't even apply if it's a corporation. So lawyers are free to screw corporations at will. They can also screw LLCs and they can screw nonprofits, just not individual people, unless you do it before they sign the retainer agreement. So let's say, for example, you're doing some legal work for a large corporation like Pepsi or Coke or AT&T or something like that. As a lawyer, you can screw them. Folks, this is an entertainment channel. It's for comedic purposes. Do we really believe that is what the rule means as applied? No, we don't. But we did want to make fun of how crazy they wrote that rule. It's insane how they wrote it. It's bad drafting. Yeah, you probably shouldn't go around screwing clients before or after they sign the retainer agreement. That's just our advice. And it's not bona fide legal advice. If you want that, you'll have to come to our law office and sign a retainer agreement.